Hi, my name is Robert Chelle with Chelle Law, and my firm assists physicians with employment contract issues. Today I'm going to talk about who owns the medical record if you are an employed physician, and then why does it matter? When you are an employed physician, you work for someone, you are an employee, and then as an employee, at least at the physician level, you're going to have an employment contract. In that employment contract, there's going to be language, and there will be language in almost every physician employment contract that states that the medical record, although the physician, may be the physician of record for that patient, the medical record itself is the property of the employer. There are a few reasons why that kind of clause is in an employment contract. First, if the contract is terminated by either party and the physician leaves, without cause, or for whatever reason the employer doesn't need the physician anymore. If there isn't language of who owns the medical record, then there could be a dispute if the physician leaves, takes the records, and then attempts to take the patients as well. And then there are also considerations about continuity of care, and then the storage of the medical record as well. That have to be, thought about. So let's kind of break that down. So first, when a physician leaves a practice, and let's just take, primary care, for instance. So if a physician works as an employee for a primary care practice and they decide to leave for whatever reason, then that practice will then send out a notice to all of the patients stating, Dr. Smith is leaving the practice. We will provide a new physician if you're interested. If not, you can pick up your medical records, at this location with some type of, written notice or something like that. The physician, once again, if they're primary care and they decide to stay within the area, the physician will also have some kind of non-compete, which will then prohibit them from working within a certain, period of time after the contract terminates, within a certain geographic distance from the practice itself. So let's say the physician wants to stay in the area. They're outside of the non-compete, so they're not violating it. They open up their own practice. They can't just take all the medical records of their patients with them. Their past employer owns the record. Now, obviously, they're the patient's record. So the patient always, in any state, there'll be something in that state's law or statutes, that kind of goes through how a patient can properly obtain a copy of their medical record. So in this case, if the physician left the practice, opened up their own practice, it would be on, the patient to then request a copy of their medical record if they wanted to move with the new physician. And then they can either ask that practice to send their, records to the physicians who left their new practice, or they can just go in and get a physical copy themselves and then take that to the new physician. So if you're an employed physician, you do not have a legal right to take all of the medical records with you. And I would suggest absolutely not doing that. It opens up liability for the physician, and it's just bad practice. Now, for continuity of care purposes, when a physician leaves a practice, generally there's a notice period. So let's say the physician wants to leave and move on to a new job. Usually they have to provide either 60, 90 days notice to their employer that they're going to leave. One of the reasons why that notice is required is to make certain that there is some kind of continuity of care for that patient. So, a new provider is either set up and will assume the care of that patient. If there isn't a provider to refer them to, then they refer them outside the organization to someone else. Prescriptions need to be taken into account as well. If bridge scripts need to be given until that patient finds a new provider. These are all things that have to be taken into account when a physician leaves the practice, but the medical record has to stay with that employer. The problems that arise are if someone who's leaving the practice physically takes the records, if they're paper. Nowadays, obviously more and more charts are, electronic with all the EMRs out there, or they could somehow get access to the medical records, download all of them, and then take those with them to the new practice. There are generally non-solicitation clauses in any employment agreement, which would prohibit that physician from actively going out and reaching out to their patients and letting them know that they're leaving, or asking that patient to come with them. So there's sometimes language in the non-solicit that would, obviously state that the record is a part of that as well. So who owns the medical record? The employer does, not the physician. If you have any questions, you can always call us at the number listed below in the description, or you can always reach us through our website, chellelaw.com. That's CHELLE law.com. Anyway, appreciate you listening to the video. Thank you.